I'm disability lawyer David Brannon, founder here at Resolute Legal. In this video, I'm going to take you through a walkthrough of the form for filing what's called a notice of readiness for your hearing before the Social Security Tribunal for a CPP disability case. Now that is a huge mouthful, but basically we'll take you through this form, what you should expect from it, so that you will know when it's appropriate to send it in and the things you have to watch out for. Now, if you like this video, hit that like button. Don't forget to subscribe. Leave us your comments. Hit the bell notification to get notice of these videos. We got them coming out a few times a week. So you filed your notice of appeal to the Social Security Tribunal for your CPP disability case. You've gotten a letter back from the tribunal that says, we've received your appeal. Please find attached the first round of documents that we've gotten from Service Canada. And oh, by the way, here is a notice of readiness form. Send this in when you're ready for your hearing. Now, we've covered this in another video. I've talked about that letter, and I've already, if you haven't saw that video, I would go back and watch that first, then come back here. But anyway, this form that we're talking about comes in a letter that you get from the Social Security Tribunal after you file your notice of appeal. The problem is that with this form, we're going to go through it here in a second, but I'll just say at the outset that the biggest mistake people make is sending this form in too soon. People are desperate. You want to get your appeal as soon as possible. You're looking at the documents you got in from Service Canada. It looks all fine to you. Let's just request this thing, get it as soon as possible because I need to get my payment started. All right. Bad decision to make. The biggest mistake we see people make is sending this form in too early. You should never, I'm confident in saying you should never send this form in without getting at least a free consultation from a lawyer. Not that the lawyer's now going to trick you into hiring them or something like that, but a lawyer, you could have a lawyer or get some idea. Have you even gotten everything ready that you need for this hearing? Like, once you send this form in, that's it. It's very hard to get documents in after you've submitted this form, and a lot of people do that too soon, okay? So the danger you face here is once you send in this notice of readiness form, you can no longer send in documents, submissions. So the time to, if you're thinking of hiring a lawyer, the time to do that is before you send this form in. You can imagine, people come to us, they've already submitted this form. We now can't go get more documents. We can't do written submissions. That basically reduces your chances of winning by so much. These cases are won and lost, not on the hearing. That's a myth. You don't win these cases by going to a hearing and saying a bunch of things and convincing the person. Wrong. You win the hearing by identifying early on what all the red flags are, the things that the decision maker is going to have a problem with, and getting the documents necessary to get rid of those red flags, to address all the concerns of the decision maker. And you put it all in a written submission to them that they're going to read before your hearing. You want to basically have them inclined to approve your claim before you even get to the hearing. If you're just getting to the hearing and that's the first time you're getting all this information to them, you are taking such a high risk in your case. And that's where most cases that are winnable are lost, quite frankly. It's, I've said before, you can lose winnable cases. That happens when you get to a hearing without all the documents and preparing the judge ahead of time for your case. That's when you're going to lose a winnable case. And you go down that path when you send this notice of readiness in too early. Enough of warning you and trying to scare you, but I wouldn't mind putting a little scare into you because of how big a problem this is. Make sure that while you're watching this video, finish till the end and get a legal consultation. Doesn't have to be from us, can be from any law firm, as long as they know what they're doing. Representative who's a non-lawyer even, as long as they're reputable and you have confidence they know what they're talking about. Talk to them and get their opinion before you file this document. Let's go take a look at it. All right, here we are. This is the notice of readiness form that will be attached to the letter you get back from the Social Security Tribunal after you file your notice of appeal. Again, I won't belabor this, but I have warned you already in the first part of this video to not send this in until you are certain that you are ready for your hearing. So let's look at this form. It's a very simple form. When you're ready to send this in, you just put your first name, last name, you indicate your tribunal number. This tribunal number is going to be on all the correspondence that you're getting from the tribunal. It's going to be stamped on the official documents you receive from them. So you're just going to put that in here. It's usually GP, the year like 20 or 21 or 19, whatever the year is that your appeal went in will be the first thing, and then it will be a number. You have to check one of these. Representation, so you're going to indicate either you have a representative or you don't. You're just going to indicate what you do here. We file these on behalf of our clients. We would prepare this form for you. We would have a representative here. And it says your representative must sign part 4 as well. So when we prepare these, we send them to you to sign. If you're doing your own, you would just click that. Declaration. Here's a big one. Flashing lights, flashing lights. I am ready for a tribunal member to decide the appeal or schedule a hearing to decide the appeal. And I have no documents that I wish to add to the file. Or I am attaching documents that I wish to have and nothing else to add to the file. Notice there's no option here for I will send more documents later, right? This is no go. Once you send this in, you are done. You can't send this in until everything is into them, including your written submissions. So it's not just that you're not going to give another medical file. You have to have in your written submissions, which is your, it's a written presentation that you give to the judge to help convince them in advance of your hearing. You tell your story in the written submissions and at the hearing, but you want to prime the judge and have them already inclined to approve your case. And you do that by getting in a good written submission. You have to pick one of these. Usually when we're doing this, we are usually this, nothing more to add. We're very, very careful about this. Again, this is an area for negligence as well. If you have a representative who sends this in too early and there were key documents that they did not provide, that's an area where you can have bad representation, right? So just keep in mind, we're very cautious about sending this thing in. Like we will double and triple check there's nothing else that we need to get, because once this is filed, you can't give any more documents, even if they're going to quote unquote prove your disability. It says here, I understand that if I send more documents after I send this form, the tribunal member might not consider those. I understand that I will be allowed to respond if another party files documents before the tribunal receives their notice of readiness. So basically what they're saying is, if you send this in, but in the meantime, more documents come in that you weren't aware of, they'll give you time to respond to them, but they're giving you 30 days basically. So that's not a lot of time. There's not much you can do in 30 days, especially if you had to go get other documents from someone else. Not going to happen in 30 days. No doctor's ever sent on file within 30 days. And okay, here we go. Somebody's tried to weasel around this. The word documents refers to documents and written submissions. Okay, that's funny because I hadn't noticed that before. So they've added this. Some lawyer, someone must have said, well, documents just doesn't refer to written submissions. And they're saying they've clarified this to say, yes, it does. Nothing else is going in after you send in that form. Then you're going to be sign it and date it. So if you're sending it, you're going to sign and date it here. If your representative is going to do it, they would sign and put their name and sign it here. So that's it. I'm not going to belabor this, but that is the notice of readiness form, and don't send this in without getting legal advice. Let's just leave it at that. It's just going to be a big problem. You don't want to be trying to hire a lawyer or other representative after you've sent this in. You will have prevented them from being effective on your case, right? So make sure to get the advice. Doesn't mean you have to hire anybody, but just get advice beforehand so that you're making the best possible decision on whether you should go ahead yourself or get a representative. And certainly do not send this form in until you get advice. There you have it. That is the notice of readiness form, the most problematic form out there. It causes more grief and difficulties for people who file it too soon without getting advice. That's it for now. If you like this video, hit that like button. Don't forget to subscribe. Hit the bell notification. We get these videos coming out a few times a week. And leave us your comments. Love to hear them. And with any videos on forums, we'll leave a link down below. We'll try to keep these links up to date. But always check on our main website to see if the forms we will have the most recent forms on that website. We'll see you next time.